After being served with a summons and the complaint, the defendant typically has 21 days to answer. After being served by an amended complaint, the defendant has just 14 days to answer. If the defendant opts to file a Rule 12 motion, as we discussed in the last clip, and then later has to answer all or part of the complaint, he has just 14 days to do so. In the answer, the defendant responds to each of the plaintiff's allegations by admitting to them, denying them, or denying knowledge of the relevant facts. However, the defendant does not need to deny allegations relating to the amount of damages unless the defendant contests diversity jurisdiction on the basis that there's not really $75,001 in dispute. If the defendant admits to an allegation, he has admitted to it and will be stuck to that admission unless he's able to later amend the answer. But the general rule is once you say admit, it's one of the facts of the case. If the defendant fails to respond to an allegation that he was required to respond to, which is most of the time, the allegation is deemed admitted by the court. If the defendant denies having knowledge of any of the relevant facts, he must state so clearly. If the defendant denies the substance of an allegation, however, it's okay to simply write denied if it is readily clear from what he is denying. But if the allegation is complicated, that is, the allegation in the plaintiff's complaint is complicated, and the denial is not going to be plainly clear from the context, he has to explain in the answer what he's precisely denying to. I object to the plaintiff stating X, or the plaintiff's allegation of X is false. If the defendant only denies part of an allegation, that is, there's a way to parse the allegation that half of it is true and half of it is false, or he denies an inference from the allegation but the actual words of the allegation are correct, the rules require him to expressly admit to the part of the allegation that he does not deny, or the non-inference, the actual text of the complaint, and specify specifically what he objects to, that half that he finds objectionable, or the inference that he objects to. To answer, the defendant must raise all affirmative defenses. Failure to raise an affirmative defense will be deemed waiver of that affirmative defense and could doom the litigation. Affirmative defenses include, now this is not an exclusive list, but it'll give you an idea of what an affirmative defense is. Assumption of risk. I am not a tortfeasor because the victim assumed the risk. Contributory negligence. I'm not liable for the tort because the victim was negligent. License. There is no tort here because I had permission to do what I did. Failure of consideration. There was no contract to breach because there was no consideration and therefore no contract. Fraud. The contract is not enforceable because I was induced to enter it through fraud. Res judicata, an affirmative defense, we'll deal with that later. Similarly, collateral estoppel. Finally, statute of limitations. I can't be held liable because the plaintiff failed to file his suit within the 3-year or whatever window specified by the statute. There are rare exceptions where failure to assert affirmative defenses results in no prejudice to the plaintiff, and the defendant raises the affirmative defense early in the process, in which we're going to allow the defendant to assert that affirmative defense despite the fact that he did not raise it in the answer. Nevertheless, if you see that the defendant failed to raise an affirmative defense in the answer and now wants to rely on it, you should assume it has been waived. These exceptions are very rare and will probably not come up in your case and certainly not on your exam, unless your professor makes a big deal out of them during the lectures. Finally, the defendant is obligated to raise certain counterclaims against the plaintiff in his answer. He also has the opportunity to raise optional counterclaims if he desires to do so, but we're going to save that discussion when we discuss counterclaims in a bit.